in the next few days, if not the week after that, the Supreme Court is going to issue some rulings. And at least one of those rulings is going to cause this nation to lose its collective mind. You know which one I'm talking about, the Dobbs decision, which will overturn Roe v. Wade. That said, there are other decisions that are coming down from the Supreme Court that, as I said the other day, are far more impactful on your day-to-day understanding of your rights than Roe v. Wade or Dobbs, whatever you want to call it. There is at least one case out there that, depending on how it's decided, conventional wisdom is the way that it's going is going to be, well, when this one hits the newspapers and the media, it's going to howl like Georgia when Sherman went through there in 1865. It's going to make this Dobbs decision look mild. The problem with the case is it's very confusing. And so virtually no one is paying attention to it right now until it's released and the media starts picking it apart going, well, what exactly does this mean? Remember the movie My Cousin Vinny? I'm going to refer a lot to this movie because this movie, in some ways, is the plot of the case that we're talking about. In some ways, not every way, but this movie, My Cousin Vinny, is hailed universally almost as one of the best legal films ever made. I don't know if you knew that or not. My Cousin Vinny is regularly used as a teaching aid in law schools because it has a very good description of the procedures that are going through there. Fred Gwynn's great line, I expect you to know the procedures of the state of Alabama. It's a fantastic film. I mean, it really is. And from a legal standpoint, it's very instructional. You will learn things watching that you will not get watching CSI or Law and Order, where they regularly bypass procedure because the bad guy needs to get, screwed. But in this film, there is a scene, obviously, at the beginning, where the two guys from New York are traveling through Alabama. They stop, they buy some groceries, and they accidentally forget to pay for one of the items. And a few miles down the road, they're arguing with each other about, don't you know what they do to people down here who steal things? And sure enough, they get pulled over by the police. And you've seen the film, so I'm not giving any plot elements away. They get arrested. As they're being interrogated, well, the one guy, Ralph Macchio, says, look, it was an accident. We didn't mean for it to happen that way. And he's kind of confessing to stealing the can of tuna. The problem is the sheriff is talking about something totally different. And he says, these words, he gets into this discussion with him and it kind of goes like this.
Let's talk about that for a moment. You paid for the groceries. And then what?
We went out to the car, and that's it.
When'd you shoot him?
What?
At what point did you shoot the clerk?
I shot the clerk.
Yes, when did you shoot him?
I shot the clerk.
Hey, Dean, we need you out here.
I'm in the middle of a damn confession here.
Whoa! Wait a minute!
So even though you have two people talking about the same thing and using the same language, they actually aren't talking about the same thing, are they? In fact, they're at odds as to what it is that they're actually talking about. And when one of them realizes that, when the kid realizes that the sheriff is talking about something totally different, he's like, whoa, wait a sec. I shot the clerk? I shot the clerk? I shot the clerk? And I know what you're saying to me, because I can already hear it. Oh, Dave, that's just a movie. There's a very complicated case that the United States Supreme Court has already heard. The decision is pending. We are waiting for it. And the facts of the case, which are no longer really in dispute, are complicated. I will try to make it simple. There's a man who is an immigrant to this country. He does not speak English as his native language. He may, to some degree, speak English, but we don't know to what degree that is. But communication is difficult. And so he works in a menial job at a facility that handles medical care for people. There comes a day where one of the clients, one of the people that he is serving at this medical facility, calls the police and accuses him of inappropriate, sexual assault, in essence. The police come and they take him aside. They begin to question him. Now, it's very important to understand to this case that he was not Mirandized. They never read to him his Miranda rights. You know what the Miranda rights are, right? You have the right to remain silent. Anything you say can and will, I've always questioned that will, but be used against you in a court of law. You have the right to talk to an attorney, have him present with you while we are questioning you. If you can't afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statements. Do you understand each of these rights I have explained to you? And having these rights in mind, do you wish to talk to us now? Now, the interesting thing about my cousin Vinny is there is a point where he waives his Miranda rights. He waives the right not to speak before the conversation, before he knows what they're talking about. I'm pretty sure a lawyer would tell you never do that, but, he was trying to be helpful. Look, we stole a can of tuna. We don't mind paying for it. We apologize, whatever. In this particular case, the man, Tico, was not Mirandized, and this is very, very important to the case. He was not Mirandized. Now, you might say to yourself, well, but Dave, don't they have to Mirandize you? No, they don't have to Mirandize you. But if you are not Mirandized, you still don't have to speak to the cops. But if you confess to a crime or whatever it is that they're investigating, even though you have not been Mirandized, you are not in custody. So therefore, your conversations with the police are not subject to the rules of evidentiary submission. Again, I know this sounds complicated, and it is. This immigrant man, was taken by a police officer to an interrogation room. The interrogation room was closed. The door was shut. There were no windows. There was no attorney present. And again, we could argue about it, but the case has already stipulated the fact that the police officer in question essentially threatened the man. He threatened violence using the gun, patting his gun. He threatened his immigration status and convinced the man in question that he needed to confess to this and he needed to come clean on this, again, all without having been Mirandized. Now, again, this isn't me suspecting something. This is in the case. You can read it yourself. You can look up the facts of the case yourself. In the process of this, the police officer had the man dictate to him a confession or a letter of apology. It's not really clear exactly what this is. Is it I did it, or is it I'm sorry you were confused by what was happening? Because the man was confessing, quote unquote, because he was cooperating with police, because he had essentially waived Miranda, even though he had never been told Miranda. And again, it's not my supposition. It's a fact. It's in the case records. He was not Mirandized. The prosecuting attorney decided to go ahead and use the letter as evidence against the man in the trial. When objection was raised, the judge overseeing the trial, overruled the objection and allowed the confession letter or letter of apology to be submitted as evidence against the man in question. Now, again, this may strike you as very strange. It's not completely without precedent, okay? And I need you to understand that. It's not completely without merit that information obtained, a confession obtained outside of Miranda could be admissible. The problem here is the police officer who essentially detained this person, even though he never technically Mirandized him, he closed the door behind him in the interrogation room and allowed no one else to be present. No lawyer, nothing. No second police officer, nothing. That's the sticking point, because it appears that the officer, whose name is Vega, essentially usurped or forced or star-chambered, if you will, a confession out of this immigrant man who was working to do his job and was accused of sexual assault. Now, you might say to yourself, well, Dave, this could go to trial and surely there would be evidence of a sexual assault. There wasn't. Do you know why there was no evidence of a sexual assault? Because it didn't happen. The woman in question either made up the story or misunderstood what was going on or something, but there was no sexual assault. Furthermore, upon cross-examination and defense presentation of its case, numerous witnesses to the incident were clear that no sexual assault had taken place. This woman either made it up in her head or something. And this police officer's obtaining of a confession or a letter of apology, because again, it's not clear what it is, was outside the bounds of Miranda and outside the bounds of proper policing. And the use of this letter by the prosecution and the allowance of this use of this letter by the judge were clear violations of the Fifth Amendment, the suspect's right to be, to not implicate himself. Sorry, my brain fog is still with me and my voice is still crap, I know. But this is important because this decision is coming soon and you need to be ready for it. Self-incrimination. These were clear violations of the Fifth Amendment, said the defense. The judge said no and allowed the evidence to go forward. Fortuitously, luckily, properly, the jury saw it differently and said, no, are you kidding? This guy's clearly innocent. This police officer clearly was out of bounds and overzealous in his pursuit of this man, going so far as to lock him into an interrogation room with the door closed without Mirandizing him. That's insane. And so they sent it back and said, no, he's innocent, not guilty. Now, you would think it would end there, right? The guy would walk away. I probably got his job back. I don't know. I didn't read that far. But the man was still pretty upset. And, of course, there are attorneys who looked at this and went, wait a sec. This is a rogue police officer. This is a problem. And if we allow this to continue, well, they're just going to do it again. Somebody needs to be held accountable for this. Someone needs to be held responsible for this financially because they have ruined this man's life. They have ruined Teko's life by arresting him for sexual assault, charging him with sexual assault, trying him for sexual assault. And even though he was acquitted, how do you get your reputation back? Is the age-old question. Somebody needs to be held responsible. So the man sued the police officer, claiming that he should be fiscally responsible for the damage done to the suspect. The courts, the lower courts, the district courts, the federal court and the district court agreed. Said, yeah, you're right. He should be held responsible for this. And they went on with it. This was appealed all the way to the United States Supreme Court by the police department because, well, if police officers are going to start being financially responsible bearing financial responsibility for their errors could open up some doors, couldn't it? The problem is, of course, who's liable for this? Is it the cop himself? And this is what the Supreme Court is being asked to decide. Is it the cop himself? If the cop is liable, as the Ninth Circuit and the district court, or the lower courts have said, police are going to have a problem with that around the country, aren't they? Because all of a sudden, suspects who may not be innocent, who may not be acquitted because they weren't guilty in the first place, might start tying things up with lawsuits claiming that, this cop didn't Mirandize me properly, this cop threw me in a room, this cop did whatever. You can see where that's going to be a real issue. But the problem is, if the Supreme Court says, no, he's not liable for it, and in essence, no one is, in order to do that, they essentially have to eviscerate a court or overturn. And again, the technicalities of this are difficult to understand. You just need to follow me here. If they say that the police officer is not accountable for this, is not fiscally liable for this, it almost requires them to upend a section of law and at least a portion of the original case Miranda, which developed into the so-called Miranda rights. Now, the Miranda rights, something you need to understand about the Miranda rights is they are not a right. They are a rule. The right you have is the Fifth Amendment. The rules, the Miranda rules, are like a fence around the Fifth Amendment to keep the police from violating your Fifth Amendment rights against self-incrimination. And it stops them from just eliciting confessions and or apologies without proper procedure. See, procedures are very, very, very important. Procedures are, well, really, I come from a world where if you don't follow the procedure and you screw something up, your career is over. This police officer didn't follow procedures. I'm sorry. You can't argue the fact that he did not follow proper procedures. I personally, on my phone, called 2 of the 3 cops that I actually know, and former cops that I actually know, and said, here's the situation. What would you do? And all of them said to me, of course you Miranda. You can't close that door without Mirandizing this guy. But this cop, Vega, did. That is indisputable. It's unarguable. He did. He did not follow the procedures. And consequently, even though the evidence may have been admissible because he wasn't technically under arrest yet, maybe he technically didn't need to be Mirandized, we threw him in that interrogation room and we sort of got a confession, maybe, or did we get an apology? Again, not completely clear. But the police officer himself took it upon himself to write the report, write down the letter that was being dictated, all of these things. There may have been a language barrier. We don't know. What we do know is that he was prosecuted using this information, and that's left us where we are today with the Supreme Court case. Can you sue the police officer himself for not following the procedures, Mirandizing, and putting you through all this hell, even though it was completely wrong? You can see where this would be a problem. You can see where if the courts say, yes, he's responsible for it, it's going to create a huge problem. But if they say, no, he's not, they, again, because of the technicalities of the way this works, they almost have to say the Miranda rule, the police have to read you your Miranda rights, they have to Mirandize you before they talk to you, almost de facto has to go away. In fact, Justice Sotomayor, at the hearing, literally said to the state's attorney, you want us to overturn Miranda. Now, the response was, no, we don't want that at all. We don't want you to overturn Miranda. Well, she continued, how do we get to what you want without overturning Miranda? And one of the most interesting comments about those oral arguments was made on SCOTUS blog was there was a lot of silence during this because everyone understands the potential problem here And everyone understands what could happen if we go one way or the other. There's like no good choices because Officer Vega didn't follow procedures. Now, in my view, he should be fired at the least, but that's outside of the realm of this discussion. For the record, we don't have the ruling yet. As of this recording on June 17th, 2022, we do not yet have the ruling. The conventional wisdom in most of the papers and bloggers and court watchers is that Miranda is going to be overturned and that police will no longer be required by the federal law under the Fifth Amendment protections to Mirandize you before questioning you. Think about the impact that could have downstream. It opens up a lot of room for abuse. This fence was built around the Fifth Amendment for that reason, because police officers, well, they weren't playing within the rules and they weren't protecting suspects' Fifth Amendment. Part of the problem is we've gotten to this insane position in our country right now where DAs and prosecutors around the country have to get those convictions. Well, my conviction rate's got to be up. We got to do all this stuff. Look at my conviction rate. My conviction rate's 97%. What they're not telling you is most of those are plea bargains. Very few of them are cases because the cases aren't as strong as they might think. But we've convinced our defendants that you can't win. And we've lost sight of the idea that it's better for 100 guilty men to go free than to punish one innocent man. We've lost that. I watched this a few years ago in Modesto with the Frank Carson murder case. I've said this before. I stand by it. Frank Carson, in my opinion, was guilty as sin. He's dead now, so it doesn't matter anymore. I think he did it. I think he knew about it. I think he covered it up. I think Frank Carson was slime. In fact, Kevin Fox and I can sit here and tell you the story of when we had Frank Carson on the show and how that went. And one of the things I said after that show is I feel like I need a shower. Frank Carson was slime. But the district attorney's office in Modesto, Stanislaus County, I don't know how you could have screwed up that case any more than if you were trying to. They had to be trying to because there's no way you could do that bad. There's just not. And in the process of this, a probably guilty man went free, and a murder victim did not get any justice. But still, that's better than punishing an innocent person for it. It's still better because this is why the rules are set up the way we are. And when Stanislaus County, the DA's office down there, completely foobarred this case, they should have lost. It shouldn't be a slam dunk. And Frank Carson, may he rest in peace, as an attorney was smart enough to know that. Whereas your average crook may not know that he can fight this in court. He may not have a good attorney. He may not have all of those things. And so we've run amok on this idea. And if we do away with Miranda as a rule, which again may or may not be the result of this, overturning Miranda simply puts it back in the state, just like Roe. It just puts it back in the hands of the state's rats people. And maybe your state says, no, we're going to keep Mirandizing people because it's the right thing to do. But maybe there are some states that will say, we don't got to do that no more. And if the legal remedy federally under the Fifth Amendment goes away, what ends up happening? It's a little more, to me, it's a tad bit more frightening than what is going on with Dobbs. Abortion's never going to go away. Abortion's not going to change. Maybe your state will ban it. Maybe your state won't. Mine won't. But my home in Oklahoma will. They already have. There are certainly discussions and arguments to be had in that realm. But in the broad spectrum of things, far more people are arrested every day than there ever are abortions. And how many of those people arrested are arrested I don't know, for something they thought they didn't do, but someone else thought they did. And you end up with, a discussion that goes round and round and round. I shot the clerk. When did you shoot him? I shot the clerk. When did you shoot him? I shot the clerk. And that turns into...
I asked him if he did it, and he said, I shot the clerk. I asked him again, and again he said, I shot the clerk.
Your Honor, no further questions.